Day of the pre-hearing of the Presidential Election Petition Tribunal, men of the Nigerian police cordon off roads leading to the court as a way of ensuring peaceful proceedings. Inside the court premises, lawyers and journalists who arrived at the court as early as 6:30 a.m. wait for the doors to be opened. Finally, the doors open and they all go in. The courtroom is filled to its capacity with mostly lawyers. The presidential candidate of the Labour Party, Peter Obi, and the governor of Plateau State, Simon Lalong, are part of the dignitaries present to witness the day's proceedings. The mood in this courtroom is one of anticipation. Some of these senior advocates have partnered each other on some cases before now, but today they are on opposing sides. The pre-hearing session begins, and the presiding justice, Justice Haruna Samani, who leads a 5-man panel of justices, sought the cooperation of all lawyers in the 5 petitions to enable the court to decide the cases on time. The lawyers leading the legal team agreed to work with the court to ensure prompt determination of the petition and to achieve justice. 3 appeals from the Labour Party, Allied People's Party, and Action Alliance were heard. One of the petitioners, Action Alliance, withdrew its petition before the court, following a petition by its lawyer, Obamadu Abuchi. The court subsequently dismissed it, following no objections from the respondents. The court also barred the governor of Plateau State, Simon Lalong, from standing before it as a representative of the president-elect, Bola Tinubu, since he is not a corporation that will need a representative. Mr. Lalong subsequently decided to represent the All Progressive Congress.
We will do all that we ought to do, leaving no stone unturned. And let me assure you that it will be obvious to Nigerians that we did our utmost best, and that election is the worst we have ever had in this country, the worst in Africa, perhaps the worst in the whole of the third world, and that is true.
Counsel to the People's Democratic Party believes the proceedings should be televised to give it more credence.
Public hearing means members of the public should be allowed, and the court got it right today when they saw that the whole courtroom was filled with only lawyers. They said no, but lawyers should try to create some space so that members of the public will also sit down and witness or watch what is going on. So this case is not just of national dimension alone, it is also of international dimension. The whole world is watching. They want to see how our justice system works.
The counsel to the president-elect, however, declined comments. Presidential Election Court will continue its pre-hearing session on Tuesday with a petition from the PDP and the APM. It also adjourned to Wednesday for continuation of hearing of the suit of the Labour Party and the APP. Emanuela Ekele, Channels Television News.
And we will stay on that matter with the news coming from the Presidential Elections Tribunal. What are we to expect? I mean, they started sitting yesterday. We had a guest here who said actually the activities of the tribunal started way before yesterday. But they started sitting yesterday, and so far, so good. What should all the parties involved, how should they conduct themselves? What should the electorate be expecting? Because all of this is about the electorate and the votes they cast. How would it go? Would it be televised, as some of the representatives there are asking that it be televised, since it's public, it's supposed to be for the good of the public. But looking at all of this, we have here in our studio Mr. Nwagwu, who's the chairman, Partners for Electoral Reform. Thank you for coming in here.
Thank you. Good morning.
And we're expecting to join us virtually Mr. Monday Ubani, chairman, section of Public Interest and Development. He'll be joining us virtually, but I'm not sure he's there yet virtually. So when he comes in, oh, there he is, Mr. Ubani. Thank you for joining us.
Thank you.
It's all right. Let's start off with you here, Mr. Nwagwu. We had a guest here who talked about the sitting of the tribunal and what they should be doing. He feels that the tribunal could actually dispense of this whole matters in less than the 180 days as stipulated by law. But you being a part of those seeking electoral reforms, I'm sure you're also happy with the Electoral Act. You're one of those who was really excited with the Electoral Act as it was passed, the 2022 Electoral Act. And we've seen it come to play in this election. Howbeit, some people argue that it wasn't fully implemented as it should. But now that the tribunal started, what have been your observations from yesterday?
Well, the Electoral Act is not that I was excited. We were part and parcel of pushing for its passage, and in fact, we did make contributions to it. So sometimes we're very uncharitable to ourselves. We don't like her taking that bragging rights, but I think I should do that at this point, especially. When you look at it around the background of the fact that the conclusion of the electoral process ends at judicial oversight. If judicial oversight has not happened, then the electoral cycle, we do always say that is a process. So the culmination of that process is at the judicial interventions that we're seeing. And so it's about the legal framework, is about the rules. And Marco, if you remember, I often say here that election is a law-guided process, and that if it fails, is a failure of law enforcement. So because every section of it is backed by a certain law. So the judiciary within the next few days will be interrogating whether, in their own words, whether there has been substantial compliance with these legal regulations and all of that. So for me is nothing, in the sense that we have gone through this process before. My challenge will always be when we start talking about when we have swollen expectations. I like to call it swollen expectations. Swollen because sometimes we can manipulate the people to have an expectation that is painted in our own canvas, in the sense that what is justice is what we want to portray as justice, is the justice of our own view. What we think is justice must be justice, and once that thing that is not our own justice is reflected, that it is not justice. So that is the minefield that I'm seeing that we are working right now. We have a situation in which, if you listen to most of the public commentary, is about the judiciary must do what is right, and then I'm asking myself, what is right in whose? Is it your own right, or what is right according to the law that is before us?
Well, is there clarity? Is there any ambiguity in the law that will cause people to be looking at it from this side? This side is the right side of the law for me. The other side is the right side of the law. No,
that's what I'm saying. The issue of justice, equity, all those things are things that you are the one who determines what is justice for you, and that is why you went to court. But there are institutions, there are people who have been saddled, who have been trained, saddled with responsibility of looking at that law. I've not been trained to do that. I've not been saddled with that responsibility. My view can as well be a tea drinking view. You know, me and Markwe or you discussing, and I'm saying this is what is justice. But at the end of the day, those who are trained will look at it from the lens of their expertise, the lens of national cohesion and unity, and then make a judgment. And what I always have called for is the respect for those institutions. So that we don't invade the kind of things that we are putting on them in a way that when their outcomes come, I know there has been episodic challenges with how the judiciary has carried itself, but I also know there has been stellar performance, stellar judgments that have at least resonated with majority of the citizens. But oftentimes, it may also not resonate with what everybody thinks. Yes.
Well, the Electoral Act 2022 was a job of work, and we saw the amount of work, the amount of lobbying, the amount of pressure that went into ensuring that members of the National Assembly passed this particular law. I mean, I'm looking at your task copy. I'm about to grab it just so I can make my point. You know, we know how much work went into it, and eventually how much lobbying. I didn't ask for your teacup. How much lobbying went into, you know, asking the president to sign it, and when eventually he did, how it was celebrated. Part of, from what I recall, or what I recollect, is the fact that during the 2015 general elections, with the introduction of the card reader, the smart card reader, what we found was that the evidences that people would have tendered at the Election Petitions Tribunal was not tenable because it wasn't backed by law. In this dispensation, the BVAS, which has been introduced by the election umpire, as well as the IREV. Now, people have said, what about the IREV? I mean, do you think that there'll be areas that will be gray? Because part of what people are asking, or part of what people are saying, was that INEC didn't live up to his own words in terms of how it wanted the results of the elections to be transmitted. Considering what is in the Electoral Act and what also is in INEC's guidelines, do you think that the courts have enough before them in terms of the backing of the law to be able to take a decision one way or the other?
Well, I think that we can look at introduction of technology in parts, because that is how it played. So the BVAS, for instance, is to do a particular work within the election period. It's supposed to identify that the holder of a PVC is the correct holder of that PVC. That's the BVAS. It's also supposed to ensure, eliminate voter identification theft. And by all the records that is available, reports of observers has shown that the BVAS performed creditably well, 98%. So that is technology also. That is the, so when you're dealing with the IREV is the conclusion, is the end point. In fact, the truth of the matter is that the election will have been concluded before IREV, because the party agents, the security, will have had copies of for EC8A.
From the polling unit.
From the polling unit, mined from the polling units. And apart from that, there's a form E60E, which is the people's result, in quote, that is also pasted in that unit. So it is at the conclusion of all of this that you now snap. You snap the form EC8A already given to party agents. And so for somebody like me, it is a checker. You have your results. If the results, because it's INEC's, the law, the constitution, the Electoral Act says INEC can now deploy whatever technology that it deems fit to be able to do its work effectively. So for results management, it imputed some kind of integrity component, which is after all of these have finished, you can go up here and check whether what happened at the polling unit is still reflective as the chain of this collation continues from the polling unit to the ward, to the RA, to the state, and then to the presidential, if it is a presidential. So you, in dealing with technology, we have to put it in that part. So it didn't fulfill its promise for the upload of results. Does not mean that technology failed in 2023, and that distinction is always very important, because oftentimes when people say technology, they didn't know that there are different components to that, and that some part of it worked effectively well. Okay, and that is important to put out there. So, but for the judiciary, it's their call. Ours is to, say what we understand from the perspective of what we know already. Yeah.
All right, let's see if we can bring in Dr. Ubani here to look at that part of the law that you talked about. Dr. Ubani, Mr. Nwagwu here has talked about the fact that every aspect of the electoral process is backed by law. And yesterday we heard the chairman of the tribunal advising the lawyers in the court and everybody there to avoid any technicalities or delays and ensure that there are no shenanigans, so to speak, to waste time. But then the question I want to ask you is, within the ambit of the law given to the tribunal to deliver its judgment or to end its sitting, as the case would be, in 180 days, are there any ambiguities in the laws backing the electoral process that could cause a delay in the dispensation of this cases?
Yeah, thank you for having me. The truth of the matter is that when 180 days was prescribed by the Constitution for the hearing of the election petition at the Court of First Instance, we were still using the old Electoral Act, where issue of technology wasn't much deployed in the electoral process. And so 180 days was used. From the time of filing to the time of delivery of judgment is 180 days at the election tribunal. But now in 2022, you now have an electoral act that part of it has a lot of technology infused into it. The issue of beavers, making sure that those who actually participate in the electoral process are known. You cannot manufacture figures anymore. And then we have the issue of IREF, result already loaded and everyone has seen it. And then you have this issue of having certified true copies of this election result from INEC. And then the new act is even reduce the number of witnesses you have to call, unlike in the previous act, where you have to involve all the political party agents from the polling unit in order to prove their case. Now, if you have the documents from INEC showing the result, it can be brought to the court, so to speak, and then admissibility of that document becomes a very veritable tool for you to prove your case. So the new act has even made it simpler, that we may not have to spend the 180 days, which is based upon the former act. But now the new act has reduced all those levels of processes that make it a bit cumbersome in proving your case as a petitioner. And so I think that the using 180 days was for a reason. Now that technology is being infused in our electoral system, we have to look at that particular constitutional provision once again in order to see what we can do to reduce the number of days within which to hear election petition. Now, if you are given 21 days within which to file, meaning there is a sense of urgency. So why are we now saying we have to take 180 days? And of course, in all other nations, people want to see a situation where the electoral process is concluded, the judicial process, which is part of the electoral process, being concluded before you swear in somebody who is alleged to have won the election. So I think there is going to be a tinkering with the law. 180 days, I don't see any problem with it. The new act has even made it simpler, for matters to be proved within a short time, rather than waiting for that 180 days within which to conclude the election petition.
All right, I think our colleagues in Lagos have questions for you.
Thank you, Nyota. Well, let me begin with you, Barrister Dr. Ubani. And I'm pretty sure that Mr. Nwagwu would also want to weigh in on the same question. There are a lot of emotions attached to this particular process, particularly the Presidential Election Petitions Tribunal. There are those who are already saying they're not likely to get any justice. It's just going to be the same old, same old. With the emotions involved, with the number of petitions from different political parties, and with the high expectations of a sizable chunk of Nigerians from different divides and different political leanings, and the emotions invested already, Dr. Ubani, what assurances can you give Nigerians? What do you think people should be looking out for that will make this, whatever the outcome is, just what Nigerians want, irrespective of their expectations? Well, Mr. Nwagwu, same question to you with the emotions involved and in this particular process, and the expectations of a sizable number of people were, right? So Ubani initially has said it's going to be application of laws, not application of emotions. But then, how easy will it be for us to dichotomize the two? Mr. Nwagwu, can you hear me?
Election is an event that is vehicled by emotions. People throw in different kinds of emotions into elections. But in terms of oversight, the responsibility of the people who oversight elections will be to look at the laws, will look at it from the lens of the law, from the lens of the regulations, from the lens of the Constitution. And it does not require emotions. What has happened and what we need to guide against, which is what I've continued to maintain, is that when you win election in your polling unit, does not mean that that election was won everywhere. And even when you win in a sizable way, it does not mean that the person has fulfilled all the conditions that the law stipulates to be able to be declared a winner. And so when you are declared a winner, it becomes the responsibility of the judiciary to say, yes, it is possible you scored this number of votes, it is possible, but did you fulfill for a presidential election, for instance? It is important. There is a reason why the Constitution, why the Electoral Act is very clear as to the spread that somebody who should be president should have. So even when you have won majority votes in a particular area, those who are oversighting this will look at the whole landscape. They will place it before them and then see whether you have fulfilled all of that. And the challenge is when we train in election observers and we tell them, look, you're observing in a particular polling unit. So when you are going to talk to the media, don't say, don't just make a call on what you saw in your polling unit, because that may not be representative of what has happened everywhere. And that is why we encourage political parties as well.
If you can hear me, Mr. Nwagwu, just one second. If you can hear me, my apologies. Just one second, Mr. Nwagwu, if you can hear me.
Represent the party, get those results for
just them. A second, Mr. Nwagwu. My apologies, my sincere apologies for butting in. All of the things that you're saying are valid. I mean, it's been our history for the past 20 whatever years now. But this one in particular, this particular election, you would agree, you referenced it earlier when you began to talk to us this morning, that a lot of emotions have been invested, is being invested, and expectations are high, to the extent, as you also referenced earlier, that a number of people are saying, why must we have the swearing in before the tribunals have stopped seating? So essentially saying, you know, that at the end of the day, what we want is justice, yes, but we expect it to go in a particular direction. And if it does not go in that direction, they may not feel that justice has been served. What should we be telling them now so that whatever happens, it will be respect for the judiciary, particularly because this is how it ought to go based on the laws that govern the elections?
The first thing is for those who are engaged in public commentary to acquaint themselves with the relevant sections of the Electoral Act. And I'm always very excited when I come to channels and I see every person holding a copy of the Electoral Act. It gives me confidence that people are acquainted, you know, relatively, albeit to the level of the ordinary person, even though there could be also lawyers. And remember that as you have 1,000 lawyers, 1,000 opinions on every matter. So it is to set up public imagination in a way that there are people who have been given this responsibility, and we should have confidence in them that they will be able to deliver what is right. In 2011, for instance, if you remember, the current president had been to court 3 times. In all of those 3 times, he's always said he won the election, that he won it, and public imagination around his own area. The truth was that he did win in a particular section of the country, but he could not go around the country and say, I won everywhere. So the judiciary interrogated it from the point in which he was losing. He was always saying that, you know, the judiciary, but once he won in 2015, the judiciary is the last hope of the common man. So we need to interpret those things correctly. That the fact that you think you have won does not necessarily mean you have won. And that was why I made the point about winning in a polling unit. You can win your polling unit convincingly. But this country is huge, 176,000 polling units, 176,000 of them polling units scattered across the length and breadth of this country. So it is possible for you to win in Ifezin, but you may not win in Ikolekiti. And you must win round. And because now there is an oversight, all of this will be put on the table. The judiciary will put it on the table, everything, and then look at it collectively. When they have looked at the votes cast, they will now again look at the spread. If somebody fulfills those conditions, it may not go down well with you, but that is what the law is. It's like the 180 days we are discussing. What is the hurry? Why you must conclude it before? There's an expectation. And that expectation is running against what your idea of justice is. Because you probably think the person who has been declared is not justice. And then you want it to be hastened. But we don't need to pander to that. We have to follow the process. It is the discretion of the judiciary to say, we can do this in 180 days, we can do it in lesser, depending on the avalanche of evidence that is available to them. But one thing that is very clear is that hallucinations disappear when evidence emerges, and that is the core of what we need to put out. Once evidence emerges, all your hallucinations, everything you are thinking will disappear. So let's focus on what we know to be the law, the current law, not what we are thinking should be the law. The law is there already. It will be interpreted, and we hope that those who have been given that responsibility will discharge it according to the oath that they have sworn to the Constitution and to God Almighty as well.
But Mr. Nwagwu, just to this one question, and then my colleagues over there can take over. There is that call by some sections of the judiciary, well, people in the courts as well, for a live broadcast of the presidential election petition ongoing process. What's your take on that? Is it permitted, or is it for or against the law?
Well, really, I can't make a call on whether it's legal or not, but I'll just tell you a story. As a member of the 2014 National Conference, we did advocate for live telecasts of our sittings and sessions. And what that, in retrospect, what that did was that a lot of people started playing to the gallery. And we are not talking to the issues. They were now talking to the cameras. And that took away the real issue. So when we went into executive sessions that were closed, people spoke their real mind and what they know to be the truth. I will give you an example. On derivation, 50% to the Niger Delta, 50% to the oil producing. When they come to the sessions, they do it. So why are you saying that when you know that? They say, if I go home, my people are seeing me. So my sense is that as important as that level of transparency is, but we are dealing with very technical issues that can endanger a judge who perhaps, stays on the course of the law and does not run on these emotions that we are talking about. Because when you do that, it will be a matter of, you are now deciding whether what the judge, and this person does no understanding of the whole gamut of the law. I think we need to be circumspect in falling for that. I think that we should have confidence that those who have the responsibility. We've had very serious cases in the judiciary that are not live televised, and I think we should.
The trial of Senator Ikwe-Madu in the UK, where the trial wasn't televised at all, but eventually the verdict was televised. People could watch, and I'm sure a lot of Nigerians have the copies of the judgment, the video judgment on their phones. For you, I don't know if you've seen that particular judgment. Do you think that that's something that we could adopt? That perhaps all of the hearings and all of the nitty-gritty can be behind the cameras, but the eventual verdict, do you think that is something that will be worth televising in a manner as clear? Because I listened to that judgment. It wasn't, you could hear what areas of law the judge had relied upon and how he reached his verdict. Do you think it's something that Nigeria perhaps can adopt?
No, it happens. It's just that it is not put out there. The plaintiffs and the defendants have copies of the judgments naturally. That is why sometimes when they finish, they say they will give the judgment, and then later they will do that. So it's there. So if the call is that for the verdict to be televised, I don't have an issue with that. But the treadmill of judicial intervention should not be exposed to popular interpretations, because that will mean that you are going to evoke those emotions, and then it can actually not lead to the outcome that we're looking to.
All right, thank you so much. We've been speaking with Nwagwu, Chairman, Partners for Electoral Reforms, and we had here in our studio, joining us virtually, Dr. Monday Ubani, who's the Chairman, Section of Public and Interest Development. We do apologize for that audio issue with you and to our viewers, but thank you so much for coming on to the show this morning.